The State of Crypto is presented by Tron, connecting the world to the power of cryptocurrency.
Let's get right into it. Obviously, there's been a lot that's happened over the last, let's say, week and a half or so. Really quickly, can I just get your initial reaction and thoughts on the Coinbase lawsuit from last week, as well as the filing that the SEC published last night in response to the mandamus petition?
Yeah, there's a lot happening for sure. And overall, I remain optimistic that in the long run, we're going to resolve these issues in a sensible way and bring clarity and certainty to the industry in a way that is long overdue. As you mentioned, last week, Coinbase was sued by the SEC. It was actually a lawsuit that was filed about 45 minutes before I was set to testify before Congress on a very important piece of draft legislation that the House Agriculture Committee, together with the House Financial Services Committee, is moving forward with. In the lawsuit itself, candidly, Nick, we weren't terribly surprised by any of the substantive claims that the SEC brought. This is a case we've been preparing for some time. And as we've been very public about, we have been, frankly, confused by the concerns and issues that the SEC has pointed to, and frankly, have been challenged in even understanding exactly what particular problems with respect to what particular products they have. So in a certain sense, the lawsuit last week was a relief because for the first time, we had specific tokens identified, we had particular products identified, and we will avail ourselves of all of our rights in court in order to defend our views. And we were also relieved, of course, that the case is really focused on some very specific topics of securities law that differ from the separate lawsuit that was brought against Binance just a day before.
So I want to get into that part a little bit. It seems to me that the fundamental question at the heart of the SEC's lawsuit against you is, the tokens identified are securities, and therefore, everything else, the allegations of Coinbase operating as an unregistered exchange, broker, and clearinghouse all stem from that kind of, that one question. Assuming, and just for a minute, if you'll indulge this exercise, assuming the SEC is able to convince a judge and a court that those tokens are securities, what does that mean for, Coinbase and other crypto exchanges?
Well, it is an assumption, and obviously one that I would strongly disagree with. But to answer your question, look, Nick, the issue of what is or is not an investment contract, which is the particular type of security that is most directly applicable to tokens, is one that the industry has frankly been wrestling with and desperate for guidance on for years. And if that weren't abundantly clear before yesterday we learned once again that even inside the building, even at the SEC, there has been, I think, not just a debate, but a strong controversy over how to properly define these assets. I'm, of course, referring to the revelations in the Hinman documents that were released as part of Ripple's lawsuit with the SEC. But for Coinbase, and I think for the entire industry, however a court ultimately resolves these issues across a range of products and tokens, we will finally have clarity, and we will be able to order our business accordingly and appropriately. And so while we are very confident we have the better view of how to define an investment contract, and that all of the allegations in the SEC's complaint are incorrect or a misread of the securities laws, one way or the other, we're going to get clarity. And for Coinbase and for the industry, that's a win in and of itself.
So to that point then, could you talk a little bit about, your maybe preview your defense in court? What is what will Coinbase say and do when you're asked to respond to the SEC's allegations?
Well, what we will say is largely in line with what we have been saying for many, many months, indeed many, many years now. These tokens that are listed, these products and services are identified, do not meet the definition of an investment contract under the Howey test and under all of the applicable federal appellate case law that has applied that test going back decades. An investment contract, Nick, first and foremost requires a contract, not surprisingly, between a group responsible for the issuance of the tokens and the purchaser of those tokens. When you have secondary trading of tokens on exchanges like Coinbase, there are no legal rights that are formed between the issuers on the one hand and the purchasers of those tokens on the other. If the purchasers, for example, are disappointed with the appreciation or financial performance of the tokens that they acquire, they have no recourse against those issuers. When when purchasers acquire their tokens for purposes that have nothing to do with appreciation at all, but are focused on utility or consumption, there are no rights created or obligations entered into by the issuers that the purchasers enjoy. So there's just a fundamental misread of the law that's taken place here by the SEC. And they've never confronted, or frankly been forced to confront, the shortcoming in their analysis under that case law, looking at Howey and looking at what an investment contract actually requires. That's the heart of the argument. We have many other defenses that will apply to one set of tokens, one type of product or another, but that's the crux of it. And we think the courts are going to see this our way because every appellate court that has looked at this issue, going back to the very beginning of the federal securities laws, has insisted that there be that type of contract whenever applying the definition of an investment contract more generally.
Gotcha. And I wonder if you could maybe contrast that with the the kind of the public strategy that Coinbase has embarked on, namely in tweets and public statements. In particular, claims like, for example, the SEC allowed Coinbase to go public. Obviously, it's a different division in the SEC that reviews these things. And even in the S1, Coinbase acknowledged that the SEC might sue one day. So I'm just curious, could you talk a little bit to, that strategy and how that might morph into or meld with the legal strategy later on?
Yeah, well, our transparency around our disagreements with the SEC is less about a public relations strategy or a communications plan. It's more about letting the public understand what its government is saying and doing, and drawing its own conclusions about whether those actions and those statements are legitimate under this current state of the law. Now, we have made the point over and over again that over 2 years ago, the SEC did allow Coinbase to publicly list when our S1 and registration statement were reviewed by the SEC, and Coinbase ultimately was able to enter into a public listing and public offering. That is not, of course, the same thing as the SEC approving our business or otherwise giving us a free pass for all time. We've never said that, and that would be an incorrect statement of the law. But it is undeniable that when the SEC reviewed our draft registration statement in S1, it had to consider whether or not the fundamental business of Coinbase was consistent with the law. And having had a chance to review our asset listing process in detail, having solicited from us many productions of documents and data to develop a fixed view of how Coinbase conducted its analysis, the fact is undisputed that we were allowed to list. There's another key element of this, Nick, that often gets overlooked. The fact is that when Coinbase went public, we accelerated the effective date of our registration statement, as many companies looking to go public often do. This is under something called the acceleration rule. And the rules that apply to acceleration explicitly require the SEC, before it allows for acceleration, to have due regard for two things. One, the public interest, and two, the protection of investors. It's written in the rule. And so for anyone to dispute that the SEC had due regard for the public interest and very much weighed the protection of investors when it allowed Coinbase to go public ignores the fact that the standard that applies to their decision to approve our acceleration request calls that out in black and white terms.
I see. Switching gears just a little bit. Last week at an event, Coinbase CEO Brian Armstrong said that the company currently has no plans to shutter its staking process or staking service. Besides the SEC, we actually saw 10 different states allege that Coinbase's staking service violates state level laws as well. It sounds like you're intending to fight those. Could you just speak to that?
Well, we are confident that our staking products and services are not securities and do not violate any federal or state laws. The reason for that is quite simple. Our products work in fundamentally different ways from others in the market that have given concern or given rise to concerns at both the federal and state level. For example, with the Coinbase staking product or service, title always remains with the customer. There's never any transfer over to Coinbase or anybody else. The customer always owns the tokens, and the customer always understands what reward, if any, they will receive. That's not something left to the discretion of Coinbase or that's calculated by anybody other than the network operator, according to the network operator algorithm. So there are just some very different ways in which our products and services work. And that's why we think we're going to be able to prevail in not just the federal case, but in each of these state cases. At the same time, every state has its own rules and own process for challenging a request to cease and desist from offering a particular product or service in their jurisdiction. We are working through those issues with each of the states. The conversations have been productive, and we look forward to resolving those over time. But in the meantime, we'll comply with any court orders that may issue, while at the same time pressing forward with our arguments that we believe distinguish Coinbase's products from others that have been the subject of other litigations in recent memory.
Gotcha. One kind of closing question. So one of the details in the SEC lawsuit was about the Crypto Rating Council, which in 2019 was this, not just a Coinbase initiative, but a multi-company initiative to try and interpret securities laws as they might apply to tokens. The SEC lawsuit pointed to this as, I think evidence in the regulators' eyes that there were some tokens that had some attributes of securities and that may or may not have then later been listed on Coinbase and other U.S. crypto trading platforms. Do you think that is sufficient, or in your view, is that sufficient to say, okay, these tokens are securities? Do you see it as a binary, or is it the case of every tenet of Howey or whichever assessment is being used has to be met to, make a firm decision on whether or not something looks like a security?
Well, Howey itself is very clear that each of the factors and requirements must be satisfied in order to establish whether a particular product or token is a security. The CRC doesn't change that. And at the same time, we think the CRC reflects the efforts, the good faith efforts, not just of Coinbase, but of the entire industry to try to get to some kind of consensus on how these different factors ought to apply and what the rules ought to be. Nick, you asked earlier about a separate matter that we have with the SEC involving rulemaking. And this is, of course, our mandamus petition that we filed with the Third Circuit Court of Appeals. Just yesterday, at the court's specific instruction, the SEC filed yet another letter in that case in which they doubled down yet again on delaying issuing any rules for this industry. And despite a circuit court ordering them to give a specific deadline by which our petition and our request will be either granted or denied, the SEC said that they would anticipate making a recommendation within 120 days. Well, that's not a deadline. That's not a commitment, even when a federal circuit court has ordered them to make one. And so, it shouldn't be surprising to anyone that Coinbase and many others in the industry have pursued efforts like the Crypto Ratings Council to try to bring some semblance of collective view and consensus around how to apply these standards, when over and over again, even when ordered by a federal court, the SEC keeps insisting that it will not engage with these issues.
Right. I guess, do you have any closing thoughts? That's really all the questions I have. But, as we looked ahead to the coming hearings and such, any thoughts you would like our audience to kind of just take with them?
Well, the last thing I'll say, Nick, is that the procedures here can be very confusing. You have cases brought by the SEC, you have counter cases brought by companies like Coinbase, you have separate cases brought against different companies like Binance and others. I'm sympathetic and can appreciate that for many in this industry just looking to build great technology and delight customers and others. This can be very confusing and perhaps even distressing and discouraging. And I just want to underscore for all of our industry colleagues that while this may not have been a fight that any of us wanted to have, this is a fight that we must have at this point in time. And obviously, Coinbase is committed to playing its part, even a leading part in all of that. But none of us should lose sight of the fact that we're doing this for a reason, which is to bring crypto to millions and hopefully ultimately billions of people worldwide with great products and services. And so my only further message to people who may be watching this is don't lose heart. This is why we have courts. This is why the rule of law is so important. And this is why we're also lucky to have an opportunity in a society like the United States to press our rights in court and not just have to succumb to arbitrary and capricious decisions by an overzealous regulator.
Got it. That's all the time we have, unfortunately, but thank you, Paul, for joining us as always.
Thank you, Nick. I appreciate it.